Assalamu alaikum wa rahmatullahi wa barakatuh. It is a distinct honor for me as a board member of the Saudi Center for Commercial Arbitration to take the stage here today at this international arbitration conference organized in Dubai with so many friends. Dubai has been, over the past 2 decades, the single city outside Europe where I have served most as an international arbitrator. And looking at the huge turnout and seeing so many friends in the room, it is extremely reassuring for me. Not because of any stage fright, I think I have gone beyond that, but because it reassures me that the mishap that I had to endure 10 years ago will not happen again. At the time, the ICC organized a conference in Marrakesh, and they said, well, George, why don't you come and lecture in this conference? And that's always a payback that you have to deliver when you accept an invitation. And the ICC said, and by the way, it's not only one lecture, it's 2 lectures. And because we have such a small time, we want you to deliver both lectures back to back within an hour. And I said, why not? We love challenges. So when I went to the Congress Place in Marrakesh, there were 2 wonderful young aides who said, Professor, we'll take you to the first conference venue and then to the second one. And I went into the first conference room and I delivered my first conference and I went out with a wonderful applause. And the 2 aides were waiting for me outside. And they took me by the hand and I was confidently following them. And they took me to another conference room. And I went to that conference room and people stopped silent when I went in. And I went confidently and smiling on the stage. And I delivered what I thought by any possible standard was the best conference I've ever delivered in my career. I stuck to the time, I delivered all my jokes, but at the end, there was a tepid applause. And people were looking bewildered. And I realized that I was addressing the wrong conference. So with so many friends sitting here today, I know that I'm not in the wrong conference. This is a historical moment, friends. This is not the first time that the SCCA comes to Dubai to talk about achievements and arbitration. Chairman Abu Numai, CEO Mera, and all the staff of the SCCA have been here before and will come back. I am confident. It's part of the spirit of cooperation. It is part of the spirit of trust between GCC member states. But today's event is a historic event, as you've heard from the inspiring opening of Chairman Abu Numai, speaking about the ambitious strategy of the center, about engaging with the judges. You've heard also from the CEO, His Excellency Dr. Mira, about the achievements of the center. And this is wonderful. And you will hear more about that with empirical data from General Counsel Chris Alberti as well. So if any of you was harboring any doubts whether you have made the right choice by selecting this conference among 24 other conferences of the Dubai Arbitration Week, which are programmed at the same time, I can tell you confidently, yes, you are here in the hottest show in town. So thank you for joining today. As I was flying over for the event from Paris, I was reflecting on the giant leap that we have seen in international arbitration, both in the Kingdom and the Emirates. And looking around the room, I see a number of veterans like me, gray-haired. And you will remember, ladies and gentlemen, how the situation was no more than 2 decades ago, when we used to fly into the Emirates or to the Kingdom to serve as arbitrators or as counsel. There were no dedicated arbitration laws. We barely had a number of provisions in the chapter on arbitration, domestic arbitration, in the Code of Civil Procedure. And the procedure will always default to judicial proceedings when it comes to any matter which is not specifically regulated in that arbitration chapter. Take the case of the taking of evidence. How do you swear fact witnesses in? And that was not necessarily the most comfortable and the safest environment for arbitration. Courts were a sword, but not necessarily in the hands of the arbitral tribunals to ensure the efficiency of the procedural decisions. More often, the scimitar was directed against the arbitral tribunal, which was, in a way, the court's approach to arbitration as a potentially illegitimate way to deprive honest citizens of their right to seek redress in the court system. And they considered that arbitration is confidential, therefore it rhymes with opaque. There is something that is open to fraud in arbitration, and that was deeply unsatisfactory. And I'm sure that you will recall a number of horror stories that we still teach our students to show them how important the development of arbitration is. You will recall in particular awards which had been set aside because they were not rendered in the name of the ruler, or enforcement had been denied because a witness was invited to deliver evidence without oath being taken first. We used to have to fly into countries in the GCC simply to sign an award with a wet signature. So fly in, sign, fly out. There were requirements for the signatory on behalf of a company of an arbitration agreement to have a specific authority, notwithstanding the fact that she would have been empowered by her company to sign the contract which embeds the arbitration agreement. The courts would still require to validate the award that the arbitration agreement itself would be the subject of a specific authority. Now, why, you might say? After all the GCC member states have ratified the New York Convention. Take the case of the Kingdom, for example. It has ratified the New York Convention since 1994. Take the case of the Emirates. It has ratified the New York Convention in 2006. Well, isn't there a cornerstone in the New York Convention in Article 2 called competence, where the courts are supposed to defer to the arbitrator to decide on their own jurisdiction? This is the negative effect of competence. The courts will allow the arbitrators to decide first whether they are competent, and then the courts will control that. Well, that was not always the case, and in fact, in many situations, that was actually reversed, with the courts deciding whether they are competent first, and then the arbitrators would have whatever is left over. Contrast that with the situation today, ladies and gentlemen, and what a giant leap we can see both in the Kingdom and the Emirates. And I will illustrate that with 3 examples. And those were not difficult to find. It reminds me of the day when the Eiffel Tower was inaugurated in Paris. So Gustave Eiffel was standing in front of the tower. That was on the 31st of March, 1889. And he was asked by the journalist, "Mr. Eiffel, what is your greatest achievement?" And he said, "Look around you." So I'm inviting you to look around you and to see the giant leap in opening up to international arbitration and in transforming the Kingdom and the Emirates into a safe seat. And my examples are threefold. First, dedicated laws. You will have noted that since 2012, the Kingdom has enacted Royal Decree 34, which is modeled on the UN Central Model Law, which is the new Arbitration Act. It was followed by an executive regulation, and where it needs to be amended, and this has happened twice already, the Kingdom will do that. Same thing on the Emirates. In 2018, Federal Law number 6 was enacted and finally offered the Emirates a law on arbitration. Second, the courts. The courts are now the shield of the arbitral proceedings. They will protect the arbitral proceedings and the integrity and the efficiency of the arbitral proceedings against guerrilla tactics. So arbitrators, you can seek support from the local courts whenever you feel that your imperium needs to be expanded with the help of the court, or whenever you feel that you're being put under pressure. But the courts have also been transformed into a sword. And this time the sword is in the hand of the arbitrators. Take, for example, Article 22 of the Saudi arbitration law, which is about interim measures. An arbitrator which seeks to have her interim measures apply to a third party will seek support of the court, and the interim measure will be given enforcement. Take the case of Article 36 of the federal law in the Emirates, which will allow any arbitral tribunal organized in the country to seek the support of the local judge in terms of the taking of evidence. I used that successfully to require a recalcitrant witness who was not willing to come to my hearing to deliver evidence. I sought the support of the judge, and the judge issued an order compelling the witness to appear. And the third illustration is the control that courts exercise in relation to the ultimate award, and they should do that. But they do that on the basis of Article 5 of the New York Convention that you see reflected in Article 50 of the Saudi Royal Decree on Arbitration and Article 53 of the UAE Federal Law on Arbitration. Awards are set aside. Awards sometimes do not get recognized. But since the enactment of those two laws, the reasons are honestly reasons that you would expect to find in Zurich, in Paris, in London, where there's a violation of public policy. No one would want an award which is tainted with corruption or money laundering or an outrageous ignorance of the parties' agreement to become part of the domestic legal system. And I tip my cap to the progress that the local courts have shown in that respect. And I would like to illustrate that by two examples of court decisions in relation to awards where I was intimately involved, and I will let you imagine how my involvement was with those awards. The first example comes from the Kingdom, and the second will be from the UAE. Almost exactly a year ago, the Court of Appeal of Jeddah rendered a decision on the 21st of November 2021, the collegial formation of the court under the presidency of Judge Ubaid al-Omari in a complex shareholder dispute. One of the shareholders had filed for bankruptcy, and the arbitral tribunal had taken evidence in accordance to what it considered was applicable in rules under the Saudi law. And there was a set-aside application, and all the kitchen sink was thrown into the application, as you can expect. There were arguments that the case is no longer arbitrable because of the insolvency proceedings. There were arguments that the arbitral tribunal has erred in accepting the evidence of fact witnesses, which had decades ago been employees of one of the parties. And the court simply rejected those arguments, indicating we are not here to review the merits of a decision of the tribunal in relation to the taking of the evidence. Arguments about misrepresentation, those belong to the arbitral proceedings, not to set-aside proceedings. And the court made a fundamental distinction, indicating that the opening of insolvency proceedings does not render a case inarbitrable because those proceedings were opened after the signing of the arbitral agreement. In contrast, when it comes to the enforcement of the award, of course you have to go through the special enforcement proceedings that apply in the case of insolvency. So it does not put into question the issue of the jurisdiction of the tribunal, but enforcement is another matter. And I suggest to you, friends, ladies and gentlemen, that this impeccable reasoning deserves the attention of the SCCA and the promotion of the SCCA, and it should be part of the syllabi that we teach to our students. Gandhi said, we must become the change that we want to see in the world. And I suggest to you that we must make the effort when we sit in the Kingdom or we sit in the Emirates to understand the applicable law. The arbitral tribunal in the Jeddah case that I mentioned had made the effort to understand the applicable law. And we've heard from CEO Mira a minute ago the exploding of the myth of arbitration. Can a woman sit as an arbitrator? Can non-Muslims sit as arbitrators? What about issues of arbitrability? When a French arbitrator sits in London, she will make the effort of trying to understand the Arbitration Act. Why wouldn't a German arbitrator sitting in Saudi Arabia make the effort to understand the arbitration rules that apply to Saudi-seated arbitration? It seems to me that this is something that we should all make in terms of effort. And when you do that, in addition to the rational explanations that CEO Dr. Mira has given all of us, you are bound to find that the reference throughout the Saudi arbitration law to Sharia is not that mystery wrapped in a riddle inside an enigma. There have been explanations which are rational about that part of Sharia which is relevant for the purpose of international arbitration, and that was the subject of a decision that was issued in 2012 by the Royal Court, indicating that what we mean by Sharia is al-qawa'id al-kulliya, those fundamental rules that are based on the Quran and the Sunnah. So when you have arguments, doctrinal arguments between schools of fiqh, they do not necessarily constitute qawaid al-kulliyah. And the International Council, international arbitrators, make the effort to understand the applicable law, and you're bound to find answers to your legitimate questions. I was recently sitting in a Saudi arbitration, a domestic arbitration case, and we had a request for the production of documents. And my co-arbitrator said, oh, it's a pity we don't have the IBA rules on the taking of evidence applicable. You don't need them, because Article 46 of the Code of Commercial Court Procedures provide for conditions for documents to be sought by a party which believes that those documents are in the possession, custody, or control of the other party, provided the request is specific, that the documents are relevant, and they are material to the outcome. Have you heard those standards before? Of course. Those are the same standards that we know and that we use every day in international arbitration in the IBA rules for the taking of proceedings. And that was because when the lawmakers in Saudi Arabia were drafting the code on commercial court proceedings, they consulted stakeholders in international arbitration. And some of us were able to propose that the IBA rules are safe standards to be applicable. Now, my second example is a case that was decided less than a year ago here in Dubai. Cassation, 12 December 2021, case 773, commercial, presiding arbitrator Judge Mahmoud Hussein. It concerned, as you would expect in Dubai, the construction of an iconic building in this country. And the case is extremely complex, and there was a set-aside application by a disgruntled party. And the court started in its decision by reminding everyone of the rationale of Article 54 of Federal Arbitration Law number 6. And it indicated that the case law of the courts in this country is not about setting aside awards. That is too easy a temptation. We're here to validate awards where they can be redeemed. And this is why paragraph 6 of Article 54 is being now systematically used by the courts to offer a chance to redeem an arbitral award. Now, you might not always agree that there is something to be redeemed, but at least you are being given a chance within 60 days to remedy potentially an ambiguous calculation method, an unsigned award, etc. And it seems to me that this is something which is sufficiently favorable to be mentioned. Now, there are still some court decisions which raise eyebrows. But tell me which country does not have from time to time some surprising decisions. For example, in this country where we're sitting, the Court of Cassation of Dubai has rendered a decision on the 14th of June, 2020, deciding that the dispositive part of the award has to be signed, but also all the reasoning leading to that dispositive. Now, I ask any of you, are you able to draw a red line between what is the reasoning and what is not the reasoning? So you err on the side of caution and you end up signing every single page of potentially a 600-page award in a construction case. And this is not necessarily satisfactory. But from time to time, we have also the same kind of surprising decisions that are handed down by the Court of Cassation in France or the Supreme Court in England. And what do you do about that? Well, I would like to quote one of my favorite novelists, the late Amos Oz, who proposed that when someone finds herself before a calamity, take the case of a fire, for example, you have one of three options. You either run away and make sure that you run faster than everyone else so that you would let them burn. Or second option, you write a letter of objection to your favorite newspaper and you indicate everyone who was involved in that fire should be demoted from their job with disgrace. Or the third option, which would be look around you, find a bucket of water, fill it with water, and pour it on fire and try to bring it down. And if you don't find a bucket, well, look for a glass and do the same. And what if you don't find a glass? Well, in that case, look for a teaspoon. All of us have teaspoons. Behind you, you have a lot of teaspoons. put some water, and put it on the fire. Now you might say, but Professor, a teaspoon is small and the fire is big. Will that serve any purpose? And my answer is, look around you. We are over 150 participants here today. If all of us have our teaspoon with water and pour it on fire, I can tell you that that fire ultimately will be contained. And Mr. Chairman and Mr. CEO, I would like to call officially today for the creation of the Order of the Teaspoon of the Friends of International Arbitration in the Kingdom and in the Emirates, so that all of us are able to share best practices and how to make arbitration in the Emirates and in the Kingdom safe arbitration and something that would rhyme with safe seat and attractive arbitration. If you agree to join the Order of the Teaspoon, make sure that you have your teaspoon well put in your pocket, ladies, in your purse, and then walk proudly with that teaspoon. Now, I'm starting to see the result of this dialogue that all of us have initiated in favor of rendering arbitration in the Kingdom and the Emirates a safer place, in particular, as concerns the dialogue with the justice. I have had the immense privilege of seeing directly Supreme Court justices in the Emirates come and open arbitration congresses. I am delighted that my friend, Judge Shamlan, the chief arbitration judge of the DIFC, is sitting with us today and is a member of the court of the SCCA. And I have had the pleasure in 2016 answering an invitation from Dr. Hamid to attend a dialogue with the judges of the Court of Appeal of Riyadh, who are the judges by default in any international arbitration-related matters. And the strive for knowledge was amazing that I saw there. And my ambition, Mr. CEO, is that this would be the beginning of a continuous dialogue with them as well. And the result is a trust. Dr. Hamid has mentioned in his report how courts throughout the Kingdom now go to the SCCA when it comes to the appointment of arbitrators in ad hoc proceedings. There were times when appointments were considered to be based on nepotism, on the momentous preference of the judge at the helms of the court. This is no longer the case. The SCCA will now provide a list to the judge, and the judge will appoint that. And this is a wonderful, wonderful thing. But let's set aside grand declarations. We've heard too many of them in the Arab world since 1948, and let's go to the hard empirical facts. And I'd like to propose to you two stops, the first in the KSA and the second in the Emirates. First, in the Kingdom. Nobody can miss the very ambitious Vision 2030 that is now the pole star of growth and in the Kingdom. It is formidable, and as I'm sure all of you have noted, the rule of law is at the heart of that ambition. Dr. Hamid has mentioned many legislative reforms that the Kingdom has seen. I would like to mention in particular the new code on commercial court procedures, enacted in 2020, the law on evidence, both of which are directly relevant to arbitration, potentially an amendment to the arbitration law, and very importantly, the draft civil code. Yes, the Kingdom is considering drafting, well, actually, it is already drafted and is being considered now for adoption, a civil code, which is a formidable change in the legal scenery. In the SCCA, you have seen also the many achievements that Dr. Hamid has mentioned and that General Counsel Chris Alberti will mention as well. And it seems to me that everything that you have heard since the beginning of the week, and you will hear more about the creation of the court, about the opening of SCCA Dubai, about the strive for more efficient and more comprehensive dispute resolution system, falls within the pole star of the SCCA: transparency, efficiency, and governance. And the same thing can be seen in this country as well, in the Emirates and in Dubai in particular. The adoption recently of the new DIAC rules is certainly a step in the right direction. The SCCA is also revising its rules, and I am confident that at some point there will be an inclusive approach, as we have seen in the adoption of the DIAC rules, for the revised rules to be the subject of a public consultation so that we can all consider offering our views to that reform. But more can be done. We all have the ambition necessary to make arbitration in this region synonymous of an efficient arbitration and a safe arbitration. Nothing is immutable. Nothing is set in stone. Switzerland has revised recently its arbitration law. The UK is set to revise its Arbitration Act. And when it is necessary, I am confident that the lawmakers, with the support of the arbitration community in the Kingdom and the Emirates, will consider the advisability of reforming the laws. There are certainly some provisions that international arbitrators and counsel who have served in the Kingdom or the Emirates under the applicable arbitration law have identified as not necessarily being optimal for the conduct of efficient arbitration. Let me share with you some examples. In the case of the arbitration law in Saudi Arabia, Article 17, Paragraph 3, that requires that proceedings are stayed when a challenge is lodged. This can be abused of. All it requires is a challenge, and then the proceedings are stayed. Article 33, Paragraph 3, which requires all participants in a hearing to sign a protocol summarizing the hearing. If we're talking about a construction case with 25 witnesses and 6 experts, I can let you imagine what the summary is about. And this is an unnecessary formalistic requirement. Article 44, particularly challenging, which requires the arbitral tribunal to file the award in original with the competent court, translated into Arabic within 10 days from the rendering of the award. So you have to race from the day you sign the award to have it translated, several hundred pages potentially, and go to the court and file it. I have received assurances from eminent judges in Saudi Arabia that this will not lead to the set-aside of the award. Notwithstanding that, it is a risk and may hinder legal certainty. In the UAE, there are still some risky provisions in the applicable law. For example, the fact that a special authority is required in Article 4, Paragraph 1, to sign the arbitration agreement in case a party is unhappy with the decision of the tribunal or the administering institution on the challenge of an arbitrator, and an appeal is lodged with the competent court, proceedings are stayed. That's Article 19.2. And Article 41.2 is something which is deeply disappointing for me and has no equivalent in the world. Dissenting opinions are considered to be part of the award. This is not something which is theoretical. I had to go through the unhappy experience of having a co-arbitrator in a tribunal where I sat, who expressed dissatisfaction with the majority opinion. It happens from time to time, except that he decided that his dissenting opinion should take the form of simply copying all the exchange between the tribunal members in the deliberation, and that was his dissenting opinion, and that was the backbone of the petition for the set-aside that was filed with the court, and gladly the Court of Cassation of Dubai has rejected that. More cooperation is required between the countries of the region. I am delighted that Dr. Hamid will be the keynote speaker at the Sharm el-Sheikh Congress on Arbitration, which is organized by the Cairo Regional Center. And thank you, Professor Abdul Wahab, for making this happen as well. I am delighted that more arbitration centers are seeing daylight in the region, the latest of which is the Oman Arbitration Center, which has been constituted by my friend Dr. Musa Al-Azri, organizing also an event here in Dubai. And friends, this is also a wonderful thing. And it brings me to have a dream. And the dream that I have is that one day all the countries in the region would organize a pan-Arab forum, perhaps even broader than only pan-Arab region forum, where we can exchange good practices and warn each other of unacceptable practices, so that at the end of the day, Arab arbitration would rhyme with safe arbitration, with efficient arbitration, and with an attractive arbitration scene. And this dream will become a reality when you see that the relationship between the two countries represented today, first the country of the institution that is organizing this event, the Kingdom, and the host country, the Emirates, is a very special relationship. a relationship which is based on trust, a special relationship which is based on cooperation. And this makes me very confident that arbitration in the GCC is going in the right direction. Enough dreams, enough visions, and let me give the floor to General Counsel Chris Alberti to give you some more empirical data. Thank you very much.